Welcome back to This Week in Immigration. I'm Jordan Lapierre. This week, immigration in the Trump budget, the rollout of Remain in Mexico, and the latest immigration court battles. All that just ahead. Before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcast. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. Hi, Theresa.
Hi, Jordan.
You can find Theresa on Twitter at BPC_T Brown. And Laura Hall, Senior Manager at BPC Action. Hi, Laura.
Hi, Jordan. Glad to be here.
Laura is on Twitter at LHallDC. All right, so we'll begin today with a look at the potential next battle over Homeland Security funding and President Trump's border wall. In its fiscal 2020 budget out this month, the White House requested $8.6 billion for a border wall, along with other funding and policy changes to advance their immigration priorities. Democrats and immigration advocates were quick to criticize those requests. Theresa, those are the broad strokes, but let's dive in a little bit. What is the White House asking for in this budget proposal?
Well, it is asking for a lot. In addition to the border wall money, it's asking for, and the border wall money, by the way, is at least 200 miles of new border wall or fencing of some kind, border barriers. But they're also looking to do a major hiring spree within DHS. So it would fund 750 new Border Patrol agents, 171 new CBP officers at the ports of entry, and 1,000 new ICE officers. It also is asking for another $2.7 billion to fund 54,000 detention beds. If you'll remember, at the end of the last fiscal year, the negotiation over continuing DHS appropriations, the number of detention beds funded was a area of some last-minute negotiations. It's currently funded for about just over 40,000 detention beds. So this would be a significant plus up. However, it also increases the number of people who could be in so-called alternatives to detention. This includes things like the ankle bracelets and a system of family case management for up to 120,000 individuals. There's other things in there that are certain to cause some discussion. For the first time, creates a mandatory border security and immigration enforcement fund. That would be a separate fund. It would be funded by several potential new fees that would be charged, including a surcharge on all immigration benefit applications that could pull in as much as $466 million, according to the budget, and increases in other immigration user fees. So all told, there's a lot in there for people to debate about. I would be remiss, and our friend Bill Hoagland would be upset with me. I didn't mention that the president's budget for the year would presume a $1.1 trillion deficit and includes $71 billion in new proposals and $37 billion in savings, so a lot of new money. And of course, that will be part of the debate in Congress as well.
So then the big question, and I'll bring Laura in on this angle, is what happens with this proposal? Congress is not obliged to do anything with it, right?
Yeah, I mean, the simple answer is nothing, probably. I mean, depending on the chamber. So the refresher and the way the kind of budget process works is first the president will submit his budget, which he's done. Then each chamber then proposes their budget. So I think we can just guess that the House, which is controlled by Democrats, will present a radically different budget than President Trump. The Senate, who's controlled by the Republicans, might be a little bit closer to what President Trump has come up with, but we don't know. They do kind of have the ability to do their own budget. And then the appropriations process begins. So they'll work their way in, and this is all assuming regular order, which isn't always a fair assumption anymore, but they will work their way through the appropriations bills, which are kind of divided up agency by agency. DHS has its own appropriations bill. Then the House will pass theirs, the Senate will pass theirs, they'll reconcile, and hopefully the president signs it into law, and the DHS is funded for another year. That's kind of how it works perfectly. This is kind of an opening gambit. This is the president has laid down kind of his priorities, and it outlines his priorities and his goals more than what might actually become law.
So I'll ask both of you then, do you see this as setting the stage for another standoff between President Trump and Congress, specifically, I think, House Democrats? The numbers in this proposal are different, but it seems like the substance of the disagreement here is pretty much the same as the one that led us to a shutdown earlier this year.
Well, certainly, I think as Laura said, this budget reflects the president's priorities, and the president's priorities are on immigration enforcement writ large, both at the border and in the interior of the United States. He's made that very clear in his first years as president. And the Democrats have a different view about that. And a lot of the hearings that they have had so far have shown the difference in how they believe immigration enforcement should be handled. And that plays out very often in the appropriations negotiations, where Congress still has the power of the purse writ large, and they can say, well, we're just not going to fund that priority. We will fund other things that we think are a priority, and the president, you should spend that money. But this is going to be a long process. Again, given that the president has shown he's not afraid to shut down the government if the things he really wants aren't funded, yes, we could get there at some point. I think we're a ways away. We're very much at the very beginning of the annual process. As Laura said, it hasn't worked smoothly any of the last several years, so it's not likely to move smoothly this year. But we're starting to see now, if you want to see where you think the differences are going to be, each of the appropriations committees and subcommittees are holding hearings right now on their particular slice of the budget. So the House and Senate Homeland Security Appropriations Committees are talking to the Secretary of Homeland Security, the head of Customs and Border Protection, the head of Immigration and Customs Enforcement, and they're asking them a lot of detailed questions about the budget, about the budget proposal, about the priorities, and also about the policies that they've been implemented. And that should give you a really good sense of where people are going to try to hold the line, where people are going to try to push the line, and where they're going to go, I think, at the end of the day.
Yeah, I agree with Theresa. I think there's still a long ways to go until kind of the deadline for when we have to have the new budget in place. But I'm not sure many of the dynamics that kind of got us in the shutdown situation last time, late December into early January of this year, have changed too much. The people in power are a little bit different. We've got the House Democrats in power, but they were already coming into power before. So I think we have that dynamic is still the same. The president seems to want X, the Democrats seem to want Y, and I'm not sure if there's much give in either of those two places.
All right, we'll check back in this fall, I guess. On the other side of a quick break, the Remain in Mexico policy takes effect. And we're back. Let's jump in now to the ongoing humanitarian challenge at the U.S.-Mexico border. Earlier this year, the White House announced a new plan it calls Remain in Mexico, which requires migrants seeking asylum in the United States to wait in Mexico until their hearing date, which could take months. The Trump administration says this plan is necessary to manage the influx of migrants arriving at the border seeking protection. Recent reports suggest, though, that the administration is struggling to implement this plan amid lawsuits from advocacy groups. Theresa, what exactly are those issues that the administration is facing in trying to put this policy into effect?
Sure. So just to recap, Remain in Mexico is what it was called until the announcement came out, and then the administration is formally calling it the Migrant Protection Policy, but everyone else is still calling it Remain in Mexico. Yeah. So this policy says that for immigrants who come to the border and ask for asylum, who are not Mexican, they can be placed in removal proceedings, given a notice to appear, but instead of being released into the interior of the United States to await that hearing, they would be returned to Mexico to await the hearing there. And this was first rolled out in California at the San Ysidro point of entry, where approximately 200 some migrants were returned to Tijuana with these notices to appear. The first group of them have had their initial hearings in the United States. There was a little bit of difficulty in some ways. There was apparently, according to the Los Angeles Times, some difficulty with the scheduling of the hearings being changed and not necessarily getting notification to the migrants in Mexico of the date and time change of the hearing. Questions about transportation from the port of entry and being able to be admitted at the port of entry. So there's still, I think, a lot of, if you will, operational things that are still being worked out. But the first several of them now have had their hearings. Of, I think, the 6 or 7 that have had their initial hearings in San Diego, several of them have asked not to be returned to Mexico. So one of the exceptions to this policy is if the migrant can express that they have a fear of returning to Mexico as well, that they believe that they would be persecuted or harmed there. Now, the standard for not being returned to Mexico there is fairly high. They have to show to an asylum officer that it would be more probable than not that they would be persecuted or harmed if returned to Mexico. That having been said, there's widespread reports of migrants being extorted, kidnapped, threatened, and or assaulted while they were waiting in Mexico. Tijuana has just been named the most violent city in the Western Hemisphere. So there is a persuasive case that the migrants are subject to harm. Whether that raises to that legal level of persecution remains to be seen. In the meantime, DHS has announced the expansion of this policy both between the ports of entry in California and possibly to other parts of the U.S.-Mexico border. We haven't seen it implemented yet, but that is part of the policy expansion that we're waiting to see what happens.
To what extent does this policy require the assent or partnership of the Mexican government? How are they involved?
So that was a little bit of an interesting thing. When the policy was announced, both governments made very clear that this was a unilateral action by the United States government to begin this policy, that Mexico had not created an agreement with the United States, but in their language, to provide for the humanitarian needs of the migrants, they would permit them to be returned under certain circumstances and would grant them temporary permits to stay in Mexico for the duration of their hearing. So Mexico basically decided it wasn't going to object strongly and would do what it could to support the migrants. But so far, as I said, the numbers are relatively small. If you look at the flow of migrants into the United States, the reports last month in February showed a significant increase in the number of migrants coming in the United States, especially families from Central America, to what are approaching some very high numbers that we haven't seen in many, many years. If this policy is expanded to other parts of the border and to more individuals, Mexico will be placed in a bit of a conundrum trying to figure out how many individuals they're willing to take back and under what conditions.
So are the challenges that we're seeing in these early weeks of implementation, are they big enough and central enough to threaten this program's goals, to threaten the government's ability to implement it?
I think the biggest threat right now is an ongoing litigation. The government has been sued over this policy in the Ninth Circuit in California. They are waiting a preliminary decision. There was a request for a temporary injunction against this policy. And we're expecting that court to rule any day now. So that's the most likely sort of next thing that might happen, is if the court in California rules against this policy, saying it's likely to not be legal, they could issue a restraining order or an injunction against implementation of the policy. And we have seen that on several other efforts the administration has had to implement policy changes relating to this flow.
So we've been tracking the debate about how to respond to the new challenges of growing Central American migration, and that debate has included, in addition to this proposal, some other ideas for handling asylum requests outside of the United States. What have been some of those ideas, and how does the implementation so far of this Remain in Mexico plan demonstrate the challenges and maybe the benefits of some of those approaches?
So back during the negotiations on restarting the government in January, the White House did at one point put on the table the idea of processing asylum applications from Central Americans, either in Central America or in Mexico. Now, this would be a unique thing. We have two processes right now. We have the refugee process, which we do when we process people overseas or outside the country who want to claim refugee status in the United States or want to be resettled in the United States. That is a very complex process that is worked with and between the United States government and, for example, the UN High Commissioner for Refugees and International Organization for Migration. We send asylum officers overseas to adjudicate these cases, and we select which immigrants we want to resettle. We tend to prioritize vulnerable populations, and there's an annual number set, both worldwide and by region, of how many refugees we will take each year. This administration has decreased that number from highs during the Obama administration. But last year, they did expand the potential number of refugees from Latin America. So that's one proposal. It did not get included in the legislative package. It would require a bit of a legislative change if we're now talking about not that traditional refugee process, but something that's more like the affirmative asylum process in the United States. So There are some ideas on the table. Another thing that was done under the Obama administration was a program called the Central American Migrant Program, where unaccompanied minors from Central America who had relatives in the United States could apply in country to come to the United States. That program was never really large. I think there was maybe a couple of thousand people altogether that applied through that program. But that concept of finding a way for people to apply from where they are rather than making the dangerous trek to the border is also one of the ideas. Last but not least, something the United States government tried to negotiate with the last Mexican government was something called a Safe Third Agreement. This is an agreement that we have with Canada, and we're allowed to have them with other countries, but it's a bilateral agreement that says that we agree that each other's asylum system meets international standards and is a safe place for people to apply for asylum. And so that if you are traveling through that country, you must apply for asylum there before you try to apply for asylum in the other country. So we'd be able to deny applicants who traveled through Mexico but didn't apply there first. We don't have such an agreement. This current government, during their campaign, said they would not sign a Safe Third Agreement, so that may be a longer-term solution. The problem with all of these is they require a lot of bilateral, multilateral cooperation. Remain in Mexico is a unilateral policy. It risks some of that multilateral cooperation and bilateral cooperation with Mexico that we probably need in the long run to address this flow. And as I mentioned, it has legal challenges against it. But I think it's also missing one important point in that we're not really addressing our own capacity to address asylum seekers. We keep finding ways to make them go elsewhere or have them apply elsewhere, but we really haven't done much to try to expand our own capacity in the United States to accept and receive and adjudicate asylum cases. As we all know, there's a huge backlog in the immigration court system. And one of the things I think we need to consider, not only now, but when we have, anytime we have a large humanitarian migration issue. And these happen from time to time. People remember the Mariel boat lift, the Haitian refugees that came in, Cubans, Haitians. We had a Chinese refugee flow in the 80s. This happens from time to time. But we don't have any capacity in our system to absorb it in a temporary and fast manner. So something we should be thinking about is some sort of surge capacity in our immigration system. Everything, including the immigration courts, asylum officers, and judges, and our humanitarian role. Our border agencies are not set up as humanitarian agencies. Maybe we need a special force or capacity that can respond in a humanitarian way to these things. So there are lots of ideas that can be put on the table. I think we need to explore all of the options at this point.
All right, we'll take one last break, and when we come back, the latest on immigration policy in the courtroom. We end today with the latest developments in immigration-related litigation. Last week, the Supreme Court ruled on whether immigration authorities can detain non-citizens without bond for past offenses. In a 5-4 decision, the court's conservatives overturned a lower court ruling limiting which immigrants could be subject to mandatory detention without bond. The decision expands ICE's ability to potentially place more non-citizens in detention for prior legal offenses. Theresa, what exactly did the court's majority opinion say about the detention of non-citizens?
So this is probably one of those really wonky, geeky technical issues that come before the Supreme Court from time to time. In this particular case, an individual had served prison time for a criminal offense, was released, was not apprehended by ICE until many years later. But because of his status and the fact that he had committed a crime, he was subject to a provision of immigration law requiring mandatory detention. And he through his lawyer sued and said, well, you could have picked me up at any time in the last 5 years, and you chose now, and you saying now I have mandatory detention when you could have found me any time sooner. Why do I not have the opportunity to say I'm not a flight risk and I can be released on bond? And the Supreme Court, the initial court said that makes sense. You should have an opportunity to at least apply for bond. The government objected and said, nope, mandatory detention means mandatory detention. And the Supreme Court weighed in and said, Essentially, yes, the statute says mandatory detention is mandatory detention. Now, the plaintiffs in the case, including the ACLU that represented them, believe that there's a larger argument, a constitutional argument, that says you can't keep somebody in immigration detention indefinitely any more than you could keep somebody in criminal jail indefinitely without the opportunity to plead for their release. So they may yet bring the court case back. On the bigger picture, and as I mentioned earlier, this administration has so many immigration lawsuits pending against it. I don't know if it's record numbers, but it's got to be close. But this is only the second, I think, relatively substantial case that the Supreme Court has heard, particularly with the new 9-judge panel. And it's a second win for the Trump administration, the travel ban and now this case. So in terms of like the track record of the Supreme Court on immigration cases, it's something to bear in mind. Most of the injunctions against this administration were issued by more liberal courts in the country. And there's always been a question about whether or not they'll be upheld in the Supreme Court. This president obviously believes very strongly that what he has done and the policies he's tried to implement will be upheld by the Supreme Court. It's a long road to get there and to get to those decisions, but I think it's something that advocates and litigants need to be considerate of, is that, the temporary injunctions and restraining orders that have been in place that, for example, are preserving the DACA program or continued presence for TPS holders, those are fragile and can be overturned at any time when the courts finally make their ruling. And we need to be sure that we're not over-relying on that as a means to create immigration policy.
And I'll just point out here that you and our colleague Chris Ramone had an op-ed in Roll Call a couple of weeks ago on this very topic of the dangers of letting the courts set so much of our immigration policy, both in terms of what it says about our system and what it says for immigration advocates who might start to see some adverse rulings.
Yeah, we need to remember that the solutions to all this really do lie in Congress. That the fact that Congress has not acted has allowed the administration of both parties to take broader and broader action in the immigration realm. That is now being challenged in the courts, and we really need to figure out how we get Congress to step back into its role of legislating to address these issues.
So going back to this particular decision, you mentioned that it hangs on the wording of a particular statute, which was a change that was made to the nation's immigration laws by Congress back in 1996. How did that 96 law change the conditions for detaining non-citizens? How did it create this question?
Sure. So the act we're talking about is the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. Most immigration wonks call it IRA. The law was in some ways a sequel to the 1990 Immigration Act, which reformed our legal immigration system, in that the 1996 Act was all about immigration enforcement. So it made substantial changes to immigration law to make more stringent the penalties for violating immigration law, to require more detention, including mandatory detention for immigrants who have certain types of criminal or other violations of the Immigration Act or other laws. And it closed a lot of provisions of law that would have allowed people who somehow fell out of status or may have been out of status but had other options to get legal status. It closed those ways that they could actually apply for that status and reinstate into legal status. So it was I'd say a product of its time. If you remember the early 90s in the Clinton administration, there was a large effort to sort of crack down on crime and, the drugs and the war on drugs and all of that. This was of a piece with that. It was the idea that strong enforcement measures would deter people from, not from violating the immigration law in any way. And so that's when these mandatory detention provisions were put in place. We are now, a couple of decades later, looking at the implications of this law. And, the courts are still wrestling with these decisions, interpreting how does this fit with the Constitution? How does this fit with other parts of the law and the Immigration Act and due process and things like that? And frankly, the intent of that law, which was to reduce illegal immigration, just objectively didn't work because the number of immigrants who were undocumented in the United States continued to rise throughout the 1990s, didn't dip or plateau until the Great Recession, and now has stabilized, but it's still around 11 million individuals. So clearly the get tough attitude didn't really work in that respect. And so one of the things I think that some people are trying to think about is, is that really the way we need to deal with our immigration issues in the United States? Is harsh enforcement, particularly with this administration? That's a lot of the debate. How much harsher could we get? And if it hasn't been proven to work so far, what makes us think that it will work now?
What does this decision change moving forward?
I think substantively, for Immigration Customs Enforcement, which is, as we started this podcast out talking about, is looking to increase the number of detention beds. It fits in well with what they're trying to do. They are at capacity, so if this decision means that they now do have to detain more of the individuals they take into custody, not sure where they're going to put them because they're running out of space. So that's going to play back into that resource allocation and appropriations conversation we started the podcast with. But legally, mandatory detention means mandatory. So what that means is that ICE will have to choose who it needs to detain. If they have to detain these individuals under law, then other people that they may want to detain but don't have to would be released. And that has created some political difficulties and public perception difficulties for ICE in the past when they have been unable to really account for all the individuals they release from custody.
All right, Theresa, Laura, thank you for joining me. That's our show for this week. Thanks for listening. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Chris Ramone and myself and produced by Emily Schrader. That's all for now. Join us again next time on This Week in Immigration.